Did medieval women only sit around, swooning and doing needlepoint? Were they completely powerless when it came to property? Did they even own land in the Middle Ages? Prepare to have your mind blown. Number 1, women's land rights declined steadily throughout the Middle Ages. One of the most persistent ideas floating around is that as the Middle Ages wore on, women's rights to land and property slowly but surely withered away like a forgotten flower. This myth suggests a constant downward slope, implying that early medieval women enjoyed some golden age of property rights that then simply evaporated under the oppressive thumb of later common law or societal shifts. But historical records, painstakingly pieced together by scholars, paint a far more complex picture, showing fluctuations, regional variations, and even periods where women's property interests were actively protected or even expanded in certain contexts. The truth is much messier and, frankly, more interesting than a simple narrative of decline. Take, for instance, the Anglo-Saxon period in England, roughly from the 5th century to the 11th century. Before the Norman conquest of 1066, customary law played a significant role, and women in Anglo-Saxon society possessed remarkably robust rights to property. A woman could own land outright, inherit it, and even dispose of it through her will, independently of her husband. The charters and wills from this era provide compelling evidence of women like Winflad, a wealthy Anglo-Saxon noblewoman from the 10th century, whose will details her extensive landholdings, her livestock, and her household goods. She bequeathed land to her daughter, to a monastery, and even to her servants, demonstrating clear control over her patrimony and acquisitions. This was not a rare exception, for the elite, even women of lesser status, held land and engaged in transactions. The very notion of a separate estate for a married woman, distinct from her husband's property, was acknowledged and protected under Anglo-Saxon custom. Then came the Norman conquest, an event often cited as the turning point where women's property rights supposedly took a nosedive. It is true that the introduction of Norman feudalism and later the development of common law in England did introduce the concept of coverture, where a married woman's legal identity was subsumed under that of her husband. Under coverture, a married woman or feme covert could not generally own property independently, make contracts, or sue or be sued without her husband joining the action. However, to interpret this as a complete and irreversible decline for all women across the entire medieval period ignores significant legal workarounds and regional differences. The Domesday Book, compiled shortly after the conquest in 1086, actually shows numerous women listed as landowners, holding estates either as tenants-in-chief or as subtenants, demonstrating that existing female landholding was recognized, even if new acquisitions became more complicated for married women. As the centuries progressed, new legal mechanisms emerged, or older ones were adapted, to safeguard women's property interests. The dower, for example, became a standardized and crucial right for widows. A widow was entitled to a life interest in 1/3 of the lands her husband held during their marriage. This was not a mere privilege, it was a right that could be enforced in royal courts. If a woman's dower was not assigned her promptly, she could initiate a writ of dower to claim her rightful share. This mechanism provided economic security for countless women across social strata, from peasant widows who held a few acres to noblewomen who managed extensive dower estates, even long after their husbands had passed. The existence and active enforcement of dower rights directly challenged the idea of a steady decline, showing a continuing legal recognition of women's stake in family land. Beyond dower, another important development was jointure, which became increasingly common from the late 14th century onwards, particularly among the wealthy. Jointure was a provision made before marriage, typically through a prenuptial agreement, where a specific piece of land or estate was settled upon the prospective wife. This land would be hers for life if she survived her husband in lieu of her dower. Jointure offered several advantages. It provided a clearer and more certain provision for the widow than dower. It allowed for more precise estate planning, and crucially, it often gave the woman greater control over her property than dower might have, as she knew exactly what her portion would be from the outset. The rise of jointure indicates an ongoing evolution in property law that, far from diminishing women's rights, actually provided new tools for securing their financial future and land ownership. Furthermore, outside of England, in regions influenced by different legal traditions, the narrative of decline simply does not hold water. In parts of France, for instance, customary law varied widely from region to region, and in many areas women retained significant property rights. In Norman customary law, married women could own separate property and dispose of it, though their husbands often needed to consent to transactions. In southern France, influenced by Roman law, women's legal capacity was generally stronger than in common law England. A woman could often own, inherit, and manage property independently, and even participate in legal proceedings. Records from cities like Marseille show women actively involved in trade, commerce, and property transactions, sometimes independently, sometimes with a male relative, but often with their own recognized economic interests. The idea of a single uniform Middle Ages also obscures the fact that legal and social conditions for women changed not just geographically, but also chronologically within the vast span of the medieval period. There were periods of greater rigidity and periods of greater flexibility. For example, the legal systems in England, particularly after the solidification of common law in the 12th and 13th centuries, did indeed pose challenges for married women's independent property control. However, the equity courts, which developed later, in the 14th and 15th centuries, offered another avenue for women to protect their property. Uses and trusts, precursors to modern trusts, allowed property to be held by one person for the benefit of another, often a married woman. This meant that while a married woman might not have legal title to land under common law, she could be the beneficiary of a trust, giving her effective control and the enjoyment of the property's income. This development provided a powerful workaround to the strictures of coverture, demonstrating legal innovation that worked for women, not against them. Even within social classes, the experience varied. While peasant women often had more limited landholdings, their customary rights to family land could be robust. In many manorial systems, a widow might inherit her husband's customary tenancy, holding the land and its obligations until her death or remarriage. Village court rules frequently show women engaging in land transfers, inheriting plots, or claiming their customary shares. These were often small plots, certainly, but they represented vital economic resources for survival and support. The records from countless manorial courts across England show women acting as tenants, buying and selling customary land, and even defending their rights in local courts. This contradicts the sweeping claim of a steady and universal decline in land rights for all women. The nuanced reality shows a constant push and pull between legal theory and practical application, with women often finding ways to assert and protect their economic interests throughout the medieval period. Number 2. Women's land ownership was rare or only for noblewomen. This myth that women rarely owned land in the Middle Ages, or that such ownership was exclusively the domain of the very highest echelons of society, queens, duchesses, and great countesses, is a pervasive one. It paints a picture where the vast majority of medieval women, particularly those outside the aristocracy, had no connection to land ownership whatsoever, whether as owners, tenants, or even as recipients of land-based income. This misconception often arises from an overemphasis on formal legal strictures, particularly English common law, which indeed made direct ownership by married women more complex, and from a lack of attention to the diverse forms of landholding and the varying social realities across the medieval European landscape. However, extensive historical research and numerous primary sources reveal a far more widespread and varied pattern of female landholding encompassing women from various social strata, from wealthy urban widows to rural peasant women. It is undeniable that noblewomen, especially those from powerful families, could and did own vast estates. Eleanor of Aquitaine, one of the most powerful women of the 12th century, ruled over the Duchy of Aquitaine in her own right, controlling immense territories and vast wealth. Her experience was exceptional in its scale, but it highlights that for women born into the right lineage, land ownership was not only possible, but a source of immense power. Isabella of France, queen consort of England in the early 14th century, wielded significant economic power through her dower lands, which were extensive and provided her with a substantial income that she actively managed. These examples are crucial because they demonstrate the absolute possibility of female land ownership at the highest levels, challenging any notion that it was universally prohibited or impossible. However, limiting women's land ownership to this elite group vastly misunderstands the medieval social fabric. Let us look at women in towns and cities. Urban environments often operated under different legal customs than rural feudal lands, sometimes offering women greater economic autonomy. In many medieval towns, especially those with flourishing trade and craft industries, women, particularly single women, femmes, souls, and widows, actively participated in the economy and held property, including urban real estate. Records from Italian city-states like Florence or Venice or German towns like Cologne show women buying, selling, renting, and inheriting houses, shops, and plots of land within city walls. A widow in Florence, for example, might inherit her husband's shop and residence, continuing his business and managing the property independently. These urban properties were not just homes, they were often vital economic assets, representing significant wealth and sources of income through rents or business operations. Consider a woman like Christine de Pizan, a renowned writer from the late 14th and early 15th centuries. After her husband's death, she supported herself and her children through her literary work, but also through the management of her inherited property. While not a massive landholder, her example represents an urban woman who maintained her independence and financial security through a combination of professional work and property management, including houses and perhaps small plots of land outside the city walls. Her ability to operate independently, while not directly tied to a great estate, still rests on a foundation of recognized property rights. Moving to the countryside, the picture becomes even more complex and challenges the Rar myth. While noble women owned castles and vast manors, peasant women often held interests in land through customary tenure. In many manorial systems, particularly in England, custom dictated how land was inherited and held. When a peasant man died, his widow often held his customary tenancy, or a portion of it, for her lifetime or until she remarried. This was not formal ownership in the same sense as feudal tenure, but it granted her the right to use the land, work it, and derive income from it, essentially acting as the tenant. Manorial court rolls, which meticulously recorded land transfers and disputes, are full of instances of women appearing in court to claim their deceased husband's land, to surrender land to a new tenant, or even to buy and sell customary holdings within the village community. For example, studies of villages like Halesowen in Worcestershire, England, or Elton in Huntingdonshire reveal numerous women appearing in court rolls as tenants exchanging parcels of land or inheriting customary holdings. A woman named Agnes, a peasant widow from the 14th century, might be recorded as holding a virgate of land, a standard measure of land in a manorial system from the lord, subject to feudal dues and services. She would be responsible for working that land, paying her rents, and contributing to the manorial economy. This was her livelihood, her means of supporting herself and her children. While she might not own it in the modern freehold sense, she certainly held and controlled it, and her rights were recognized by the customary law of the manor. These were not isolated cases, they were an integral part of the medieval rural economy, demonstrating that women were active participants in landholding and management at the village level. Furthermore, single women, known as femmes souls in English common law, had remarkably extensive rights to property. An unmarried adult woman, whether a maiden or a widow, was treated as a legal person. She could own land, buy and sell it, enter into contracts, and sue or be sued in her own name. Many women chose to remain single, or were widowed and did not remarry, precisely to maintain this legal and economic independence. A single woman in a town might inherit a prosperous business and its associated properties from her parents, managing them effectively without the need for male guardianship. A widow, having already experienced marriage and often having built up resources, could be a formidable economic agent, using her dower lands or inherited property to engage in trade, lend money, or even run significant enterprises. The existence of these femmes souls with full property rights challenges the idea that women's land ownership was universally rare. The regional differences further complicate the simple narrative. In areas of Scandinavia, women often held strong inheritance rights, including to land. In parts of Eastern Europe, and even in some Celtic legal traditions, women's land rights could be more robust than in common law England. The concept of partible inheritance, where land was divided among all heirs, including daughters, existed in many places, leading to women inheriting direct shares of family land. While often smaller, these shares were still forms of land ownership. So, while a noblewoman might own a duchy, a peasant woman might hold a few acres of arable land or a cottage plot, and an urban woman might own a shop and a house. Each, in their own way, was a landowner, debunking the myth that such ownership was either rare or confined to the very top of the social ladder. Number 3. Women had no control over their land, even if they owned it. The myth that even if women technically owned land, they had absolutely no real control over it, often paints a picture of passive female figures whose property was managed entirely by male relatives, husbands, or guardians. This narrative suggests that women were mere titular owners, holding deeds or titles, but lacking any actual agency and decision-making regarding their estates. This implies that they could not manage their properties, make economic choices, negotiate with tenants, or defend their interests in court. However, historical records consistently reveal numerous instances of medieval women, from various social classes, actively managing, defending, and even expanding their landholdings, demonstrating a remarkable degree of control and economic acumen. The reality was far more dynamic and involved women as significant actors in the medieval land economy. Let's first consider the vast dower lands assigned to widows. As discussed earlier, a widow was entitled to 1/3 of her deceased husband's lands for her lifetime. These dower lands were not simply given to her for passive enjoyment, she was expected to manage them. This often involved overseeing tenants, collecting rents, maintaining buildings, ensuring crops were sown, and even participating in local legal disputes concerning her dower properties. Noblewomen, in particular, could find themselves managing extensive dower estates scattered across multiple counties or even kingdoms. Take Eleanor of Provence, the Queen Dowager of England in the late 13th century. After the death of her husband, Henry III, she effectively managed her substantial dower lands, which provided her with a considerable income. She had her own financial administrators, bailiffs, and stewards who reported directly to her, and she made crucial decisions about the agricultural practices, tenancy agreements, and finances of these estates. This was not a hands-off arrangement. It required active oversight and strategic planning. Beyond dower, women who inherited land as feme souls, single women, or widows exercised full control over their properties. A medieval heiress, if unmarried, could be a very powerful figure. She controlled her own inheritance, and any future husband would gain control only through marriage, and even then, often with various legal safeguards in place. For instance, Alice de Lacy, Countess of Lincoln, in the early 14th century, inherited vast estates. Though she faced significant challenges and was married multiple times, her ownership of these lands was a crucial element in her political and economic standing. She engaged in legal battles to protect her patrimony, demonstrating active engagement and control. Even when married, women could influence decisions concerning their lands. While a married woman's legal capacity was limited under coverture, a husband often still required his wife's consent for major transactions involving her inherited land, such as alienation, selling, or mortgaging. This was often recorded in legal documents where the wife's agreement was explicitly stated, sometimes even requiring her presence in court to confirm her consent. This consent, while not full control, was a significant check on a husband's power over her land. Furthermore, women frequently engaged in legal actions to defend their land rights. Court records, from the royal courts down to the manorial courts, are replete with women initiating lawsuits to protect their property, claim inheritance, or recover lands that had been wrongfully taken from them. For example, the rolls of the English royal courts in the 12th and 13th centuries show women pursuing writs of right or writs of novel disseisin to recover unlawfully dispossessed lands. These were complex legal procedures that required active participation, knowledge of one's rights, and the ability to articulate one's case. A woman pursuing such a claim was far from a passive bystander. She was a litigant fighting for her property. Consider the example of the Paston women, a prominent gentry family in 15th century England. Margaret Paston, wife of John Paston I, was a formidable figure who frequently managed the family's estates in her husband's frequent absences. Her letters reveal a woman deeply involved in the practicalities of land management, dealing with tenants, resolving disputes, overseeing agricultural work, and even defending their property from armed incursions. She was responsible for the income from their land, making decisions about how to best maximize returns and ensure the family's financial stability. Her management was not merely administrative, it was active and strategic, often involving difficult and dangerous decisions. This level of active management challenges the idea of women being disengaged from their land. At the village level, peasant women also exercise forms of control over their customary land holdings. A widow holding a customary tenancy from the lord of the manor would be responsible for working the land, paying her rents, and fulfilling her labor services. She would attend the manorial court, where land transfers were recorded, and would participate in the community's economic life. She might negotiate with neighbors over boundaries, manage her crops, and even make decisions about buying or selling small parcels of customary land. These were not grand acts of ownership, but they were crucial acts of control over the resources that sustained her and her family. Records from village courts, like those of the Manor of Wakefield in Yorkshire, show women regularly involved in these land transactions, asserting their rights and making economic decisions. Another form of control, often overlooked, was through women's wills. While perhaps more prevalent among the wealthier classes, women were able to bequeath their movable goods and sometimes their land, especially if it was acquired by purchase, or was part of a separate estate not subject to rigid inheritance laws through their wills. The ability to make a will and specify the disposition of one's property after death is a profound act of control. Women's wills provide intimate glimpses into their property holdings and their wishes for how those holdings should be distributed, demonstrating that their ownership extended to the power of testamentary disposition. The complexities of medieval legal systems, especially the interplay between common law, customary law, and equity, often provided avenues for women to maintain control. While common law might restrict a married woman's direct agency, the development of uses early forms of trusts allowed land to be held by a third party for the benefit of a married woman. This meant that while the legal title might rest with the trustee, the married woman had the equitable interest and derived the income from the land, effectively controlling its economic benefits. This innovation allowed many women to circumvent the limitations of coverture and exercise significant control over their property's proceeds. The very existence of such legal workarounds underscores the persistent desire and necessity for women to maintain control over their land and the willingness of the legal system to accommodate, even if indirectly, those needs. The notion of complete lack of control is simply not supported by the diverse and dynamic historical evidence. Number 4. Women lost all land rights upon marriage. The idea that a woman, upon saying "I do," instantly and irrevocably surrendered all her property rights, particularly her land, to her husband is one of the most stubborn and widely believed myths about medieval women. This misconception often stems from a simplified understanding of coverture, the legal doctrine primarily prevalent in English common law, which indeed meant that a married woman's legal identity became subsumed into her husband's. However, to state that all land rights were lost is a gross oversimplification that ignores crucial nuances, legal provisions, and regional variations that allowed women to retain significant interests in land throughout their married lives, and, crucially, upon widowhood. While a married woman's ability to transact independently was certainly curtailed, her underlying land rights were rarely completely extinguished. The concept of coverture itself, while powerful, was not a total erasure of a woman's premarital property interests. Under English common law, a husband gained control over his wife's real property land during their marriage. This meant he had the right to manage it, to collect its rents and profits, and to make decisions regarding its use. He could even sell or mortgage her land, but generally this required her consent, especially if the land was part of her inheritance or patrimony. This required consent, often formally recorded in a court where the wife was questioned separately to ensure her willingness, was a significant check on his power. It demonstrated that her interest in the land, though controlled by him during marriage, was not simply his to dispose of at will. The land remained legally hers in reversion, meaning that upon her husband's death, or if she outlived him, the land would revert to her or her heirs. It was a temporary suspension of control, not an absolute loss of ownership. One of the most important provisions that contradicts the all rights lost myth is dower. Dower was a widow's right to a life interest in 1/3 of all the lands her husband had possessed at any point during their marriage. This was not a gift or a privilege, it was an inalienable right, legally enforceable. Upon her husband's death, a widow could claim her dower, and, if it was withheld, she could sue in royal courts to have it assigned to her. These dower lands provided her with an income and a place to live, ensuring her economic security after widowhood. For many women, dower represented their most significant land interest and often a substantial portion of their wealth. The existence of dower proves beyond a shadow of a doubt that a woman's connection to land was not severed by marriage, but rather transformed and protected, particularly in the event of her husband's demise. The very concept of dower presupposed her previous claim to her husband's property, even if she couldn't manage it directly during his lifetime. Furthermore, jointure, which became more common in the later Middle Ages, particularly among the aristocracy and gentry, also shows women retaining land rights. The jointure was a pre-marriage settlement where specific lands were granted to the wife to be hers for life, if she survived her husband in lieu of her dower. This arrangement offered more certainty for the woman, as the specific lands were identified beforehand. While she wouldn't manage these lands during her husband's lifetime, her future right to them was secured by a formal legal agreement, often recorded in deeds or charters. The widespread use of jointures illustrates a deliberate legal strategy to ensure women's continued land interests, even while married, looking towards their future economic independence as widows. Beyond these provisions, there were also exceptions and workarounds. A married woman could, under certain circumstances, hold separate property, especially if it was specifically designated for her, separate use through a trust or use. As precursors to modern trusts, allowed property to be held by a third party for the benefit of a married woman. This meant that while her husband would technically not own or control the property directly, she, as the beneficiary, would receive the income from it and could often exert significant influence over its management. This mechanism allowed women to protect inherited wealth or acquire new property that remained outside their husband's direct control, providing a vital means of retaining land rights. These trusts were not uncommon among the wealthier classes and demonstrate a sophisticated legal understanding designed to circumvent the strictures of coverture for the benefit of married women. The myth also fails to account for regional variations in law across medieval Europe. While English common law heavily favored the husband's control over a married woman's property, other legal systems offered more expansive rights. In parts of medieval France, especially those influenced by customary laws, married women often retained more independent control over their own property. For example, in Normandy, a married woman could keep her own property, inherit it, and even dispose of it, though her husband's consent was often required for transactions. In the Midi region of France, where Roman law influences were stronger, women generally had greater legal autonomy, including over property both before and during marriage. Records from towns in these regions show women actively buying, selling, and leasing property, sometimes with the assistance of their husbands, but often with their own recognized legal capacity. Even within England, certain legal customs and practices differed. In some boroughs and cities, local customs allowed married women thieves, souls merchants to trade independently and own property associated with their trade, even if the general rules of coverture applied to other aspects of their lives. A wife of a merchant in a town like London might run her own business, own the shop premises, and manage the associated finances, quite independently of her husband. This exception for merchant wives shows a pragmatic recognition of women's economic activity and a willingness to adapt legal norms to facilitate it, indicating that all rights lost was far from universal. Finally, the concept of communal property in some peasant communities also meant that married women, as members of a household, had a direct, albeit shared, stake in the family's land. While the male head of the household might formally represent the family in transactions with the lord, the wife's labor and participation in the management of the land were essential to its productivity and the family's survival. Her rights were often customary and deeply intertwined with the household's ability to derive sustenance from the land, demonstrating that her connection to the land was fundamental, even if not expressed through individual legal ownership in the same way as a feme soul. The nuances of communal land tenure and household economies show that women were active participants in landholding, even if their individual rights were often intertwined with their husbands. The broad claim that all land rights were lost upon marriage ignores the diverse legal, customary, and social realities that shaped medieval women's relationship with land. Number 5, women couldn't own land at all. This is arguably the biggest and most outrageously incorrect myth of them all, the sweeping statement that women in the Middle Ages simply could not own land. This myth is often presented as a universal truth, painting a picture of medieval society where women were entirely excluded from property ownership, left without any direct stake in the most fundamental source of wealth and power of the era. Such a claim fundamentally misunderstands the diverse legal systems, customary practices, and social realities that existed across the vast timeline and geography of the European Middle Ages, from the fall of Rome to the dawn of the Renaissance. The historical evidence overwhelmingly demonstrates that women not only could, but frequently did, own land in various forms, for different reasons and under different circumstances. Their pathways to land ownership were varied and resilient. First and foremost, let's address the most straightforward examples: single women and widows. In nearly all medieval legal systems, an unmarried adult woman, whether a maiden or a widow, was considered a feme sole, a woman alone. As a feme sole, she possessed full legal capacity. This meant she could own property, including land, in her own right. She could inherit it, buy it, sell it, lease it, and manage it independently. She could enter into contracts, sue, and be sued in her own name. This right was fundamental and widely recognized. Numerous charters, deeds, and court records attest to single women and widows inheriting substantial estates from their fathers, brothers, or husbands, and subsequently exercising full control over these properties. Consider the example of the countless widows who inherited dower lands. As established, a widow was entitled to a life interest in 1/3 of her deceased husband's lands. This was not merely the right to use, it was a form of temporary ownership. She became the tenant-in-chief of those lands for the duration of her life, responsible for their management, revenues, and any associated feudal obligations. Some dowers were truly vast, making the widow a significant landowner in her own right. For example, Queen Eleanor of Aquitaine, upon the death of her husband Louis VII of France, reasserted her full rights over the Duchy of Aquitaine, which she held in her own right. Though a royal example, it illustrates the principle that women could hold major territories as their own. Less grand, but equally important, were the thousands of peasant widows who held their customary tenancies, sometimes just a few acres, but enough to sustain their families. They were the recognized holders of these lands within their village communities. Beyond dower, women inherited land as heiresses. If there were no male heirs, or if local custom dictated partable inheritance among all children, daughters could and did inherit land directly. Many powerful aristocratic families, particularly in the absence of a male line, saw their fortunes pass through a female heiress. Such a woman would bring significant landed wealth into her marriage, which, while often controlled by her husband during the marriage, was recognized as her inheritance. The title and the reversionary interest in the land remained hers and would pass to her children. For example, Isabel de Clare, Countess of Pembroke, inherited extensive estates from her father, Richard de Clare, in the late 12th century. Her inheritance made her one of the wealthiest women in England and Ireland, and her landholdings were unequivocally her own, albeit managed by her husband upon marriage. The diversity of legal systems across Europe also played a crucial role. While English common law developed specific restrictions on married women's property, other regions had different norms. In parts of Scandinavia, women often had strong inheritance rights, including land. In Castilian Spain, the arras dowry, given by the husband to the wife, and ganancias, property acquired during marriage, often gave women significant independent property rights within marriage. In many parts of medieval Germany and Italy, particularly within urban centers, women retained greater legal autonomy over their property, especially if it was part of their dowry or inheritance. The records from Italian city-states show women actively buying, selling, and owning urban property like houses and shops. Even within the context of coverture in England, which merged a married woman's legal identity with her husband's, the idea that she could not own land at all is incorrect. While she could not manage or alienate her inherited land independently during marriage, the land remained legally hers in reversion. It was essentially held in trust by her husband for the duration of their marriage. Upon his death, or if the marriage ended, the land would revert to her and she would regain full control. This distinction is crucial. Control was suspended, but ownership was not extinguished. Furthermore, land purchased by a married couple was often held in joint tenancy, meaning both husband and wife owned it. If one died, the other automatically inherited the full interest, which often meant the wife surviving her husband would gain full, sole ownership of the acquired land. The very concept of a dowry, a gift of property, often land, but also money or goods brought by the bride to the marriage, demonstrates women's connection to property. While the dowry often fell under the husband's control, it was fundamentally her property, intended to contribute to the new household and, in some legal traditions, revert to her or her family if the marriage failed. In regions where dowry customs were strong, women were seen as significant economic contributors to the marriage, bringing tangible assets, including land, that were recognized as their own. Finally, women's involvement in specific economic roles also provided avenues for land ownership. Female monastic foundations, for example, often owned vast tracts of land, held collectively by the abbess and her nuns. Abbesses were powerful landholders managing extensive estates, overseeing tenants, and participating in feudal obligations, much like their male counterparts. While this was corporate ownership, it was ownership by women, for women, and managed by women. Even within secular society, women often held property through their involvement in guilds or crafts, sometimes owning the workshops or land on which their businesses stood. The widespread availability of wills and charters from the medieval period, which explicitly detail women inheriting, owning, and bequeathing land, directly refutes the myth. These documents are not isolated curiosities, they are abundant and span centuries and regions. From the wealthiest noblewoman with her vast estates to the village widow clinging to her few acres of customary land, women's connection to land ownership was a tangible and significant reality throughout the Middle Ages. To claim they couldn't own land at all is to ignore mountains of historical evidence.